and contempt or bond violation hearing. And People v. Oliver Hill. It's file 24-6932FH. Counsel, please state your appearances.
Melissa Goodrich, Wayne County Prosecutor.
Luke Kukoski on behalf of Mr. Hill, Your
Honor. All right, good afternoon. Mr. Kukoski, do you know how we're proceeding today on the docket call and on the contempt matter?
Well, Your Honor, I believe my client would like a hearing in the matter.
Okay, Ms. Goodrich, any opening remarks?
No, Your Honor.
Okay, Mr. Kukoski, any opening remarks?
Well, Your Honor, we plan and intend to, through the hearing, show that my client, although had some deviation in the monitoring of his ankle device, there was no alcohol use. There was no alcohol that can be testified to. And in fact, my client did take a urine test amidst all this deviation and tampering, alleged tampering of the device. And I'm not sure what defendant in their right mind would do that. So we're prepared to go forward with those proofs.
Okay, and Ms. Goodrich, your first witness.
I'd like to call Lainey Fryer, please.
I do see Ms. Fryer in the Zoom meeting room. All right, Ms. Fryer, can you see and hear us?
I can, Your Honor. Thank you.
Okay, would you please raise your right hand for me?
Mm-hmm.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, go ahead, Ms. Goodrich.
Thank you. Can you start by stating your name for the record, please?
Yes, Lainey Fryer.
And where
I guess I would object to testimony by Zoom, given the nature of the hearing, the burden of proof beyond a reasonable doubt. I would ask the court and ask that we have a witness be in person here.
Ms. Goodrich, your response?
Your Honor, I believe that the court rules allow for discretion of the court to use Zoom, and typically the practice of this court is for bond and probation violations that we do use Zoom testimony for efficiency for the witnesses who are often far away and needing to travel otherwise.
All right, Ms. Fryer, we're going to continue with your testimony by Zoom right now. The prosecutor has some questions for you.
Thank you. I think we left off on where you're employed.
I'm employed at Home Confinement Incorporated.
And what is your position there?
I am the Director of Business Development and the Director of Compliance.
Okay, and how many years have you been employed there?
I've been with Home Confinement for 4 years, and prior to that, I worked in the judicial system for over 30 years as a probation officer, court reporter, and Director of Probation.
Thank you. And are you familiar with the defendant, Oliver Hill?
I am.
And are you familiar with the Scram Systems non-compliance report for Oliver Hill's case dated April 14th of 2025?
Yes, I do have a copy of it in front of me right now.
Okay. And what was the non-compliance in this report?
The non-compliance, the date of the non-compliance, confirmed event, April 14th, 2025. And if you flip to page 4, it's going to verify that it was a confirmed tamper event with alcohol detected. That does not mean it was a confirmed alcohol event. It just means it was a confirmed tamper event with alcohol detected.
Okay. And can you further explain what that means? What constitutes a tamper event?
Absolutely. And if I don't know if you would like, counsel, but I can explain briefly the technology behind the cam prior to going into that, or I can just go right into it.
Yes. No, if you could explain the technology first.
Absolutely. So the cam alcohol tether acts like a breathalyzer, but it's worn on the ankle. It is designed to pick up transdermal alcohol concentration. And what that is when a person ingests alcohol, the alcohol will be metabolized throughout the body, except for 1%, which comes out in impermeable sweat vapors. So the alcohol tether is designed, it takes a reading approximately every 30 minutes through a faceplate, similar technology to fuel cell sensor. It's going to pull in a sampling, and it's going to determine whether or not there is a TAC, transdermal alcohol concentration, within that sweat vapor. That's one of the technologies, the primary technology. The couple other technologies of this device is it has a IR infrared technology, and that is to determine whether or not there is a tamper. If one is trying to tamper either intentionally or unintentionally with the equipment. So the IR infrared at the time of installation is going to take a baseline reading, infrared reading of that, the fit. And what that's measuring for is the light reflected between the alcohol tether and the skin. Our manufacturers always want to give the benefit of the doubt to the user. So there is an allowable 12% deviation of that IR baseline reading, because we know people are walking, the bracelet is going to be moving a little bit around the ankle, but it still should fit tightly like a wristwatch around one's wrist. So the infrared is going to pick up these readings, and when there is a 12% or greater deviation for 3 hours or more, and this is also listed on page 3 if you want to follow along. When there is a deviation of 12% or more for 3 hours or more with the presence of alcohol, that will trigger a tamper event. Now, without the presence of alcohol, meaning without a TAC reading, without the presence of alcohol, that window is expanded to 8 hours or more. So a user would have to have something in between their skin and the tether. And once again, that tether fits snugly around the ankle for 8 hours or greater before there is a tamper alert that is triggered. There also is a temperature technology on it as well, but basically that's going to take into account the person wearing it, their temperature, as well as external, if they're outside playing basketball, it's going to be hotter in the summer versus maybe shoveling snow in the winter. So that technology is really to determine whether or not an offender actually cuts off the device. And there has been an incident where someone has passed away, and we saw a huge dip in the temperature reading. So I just wanted to mention all 3 technologies that were designed into the tether.
Okay, and in this case, the confirmed tamper was without alcohol detected?
No, this confirmed tamper was with alcohol detected, but it's not a confirmed alcohol event, meaning that I cannot testify today whether or not he ingested any form of alcohol, because it did not meet the criteria required to come back as a confirmed alcohol event. I can testify that there was a confirmed tamper event, and the details of that event are listed on the bottom of page 4.
Thank you. And does the home confinement, when they issue a tether to a defendant, is there a protocol on instructions on how to wear the tether and what to do and not to do?
Yes, there is. There is. And Mr. Oliver did sign it. If you want to just wait 1 second for me, I can pull it up. I can even email it to you if you need, and I can read it to you for verbatim if you just give me 1 moment.
Yeah, I would object to the witness testifying or reading verbatim from a report that's not been admitted as an exhibit. I understand refreshing recollection and refreshing memory, and the fact the witness is looking at a report to do so, but we're getting very close to the line of where I think it's improper.
Okay, so Ms.
testifying based on this.
All right, so Ms. Fryer, if you don't look up something while you're testifying then, okay? So
Of
just
course,
testify from your memory, and then the prosecutor will go from there.
Absolutely. I was just going to try to read
Go ahead.
verbatim, but absolutely, I can tell you. And we do give each offender a packet of it's the client agreement, a packet. Within there is going to contain the rules, the do's and don'ts of wearing the alcohol tether. We do indicate in there that they are not to consume, ingest any form of alcohol.
I
We
would
talk-
object.
Hang on a
It's not been
second.
a question asked of the witness, and the witness is testifying to in general's opinion. It's not based on a specific, whether Mr. Hill has gotten that material or not.
She's answering the question that was asked before your objection, and she's describing their general procedures, which is admissible. Continue, Ms. Fryer.
So we speak about, what products to avoid that contain any form of alcohol, cleaning products, colognes, etc. In there also, we talk about that they cannot get anything in between their skin and the tether, as that could possibly prompt a confirmed tamper event. So that is also written within the body of the document that we do provide each offender.
Thank you. In your honor, I'd move to admit People's Exhibit 1, which is the Scram Systems Non-Compliance Report, which we've been discussing.
Okay, Mr. Gutowski. Any objection?
So I have an objection to the foundation of the exhibit that's being offered. There's been none laid at this time, Your Honor. And so I'd object to the admission of that.
Or if you want to lay out the foundation.
Yes, so the Scram Systems Non-Compliance Report, when there is a violation of the tether, this is a report produced by your company, correct?
That is correct.
And this is the regularly used format of the report when there is a violation by a defendant.
That is correct.
And you've had the time and ability to review this report, and it accurately reflects the report of Oliver Hill. It says report date Wednesday, April 16th of 2025.
That is correct.
Your Honor, I move for the admission of People's Exhibit 1.
Mr. Gutowski. Any objection?
I would still have the continuing objection, Your Honor, to the foundation.
Okay, overruled. Exhibit 1's admitted.
I have no further questions.
For the cross-exam.
Yep. Do you know when Mr. Hill was placed on the Scram unit?
Yes, he was installed on January 31st, 2025.
Okay. And when did the deviation or I guess alleged tampering occur?
So once again, I'll reference page 4 of the admitted document. At the bottom, it goes through the criteria. To answer your question, it's number 3. The deviation outside of the acceptable variance began on Monday, April 14th, 2025 at 9:08 a.m.
Okay. And so he's had that device. Were there any other tampers alleged on that device?
No, Counselor, this was the one and only violation that Mr. Hill received. He was placed on cam January 31st of this year, and it was deactivated on May 5th of this year.
Very good. And so over the course of about 3 months, this is the only violation or tamper event that you would have in your system?
That is correct, sir.
Okay. And you cannot confirm or testify to any sort of alcohol being involved with that?
No, that did not meet the criteria required to come back as a confirmed alcohol event. So I'm only able to confirm the tamper event that we're speaking of.
Okay. And you would admit that these devices are not perfect. There's a variation of about 12% that give or take for the reading of the infrared. Is that correct?
No, that's not correct. There is probably, these devices are about 99% accurate. When we're speaking about the 12% deviation, that's not an error. What it means is that the light reflectivity that the IR sensor shoots out an invisible beam of light, and it's measured in voltage. That means that there was more than a 12% change in voltage that is required over a specific period of time, either 3 hours with the presence of alcohol or 8 hours without the presence of alcohol, that would be required to come back as a confirmed tamper.
Okay. So there's window there. It's not a perfect system. You just said it's about 99% was your testimony, but there is variations that occur, and these are not perfect devices, correct?
These devices are about 99% accurate.
Okay. And as regards to the temperature variation here, those variations occur whether the client's outside, they can change, whether they're inside working, those conditions cause the temperature reading to change. So there could be a variance there as well, correct?
Yes, but the temperature variance has nothing to do with the confirmed tamper. It's a different technology.
Okay, well, your report indicates that the tampered technology contained in this trace at page 2 includes both infrared sensor and temperature sensors. So to determine whether a violation or a tamper has occurred, it clearly indicates that there needs to have the infrared sensor and the temperature sensor.
Yes,
Is that
but
correct?
he did not cut off this tether, nor did he pass away. That's when the temperature sensor would come into play with a tamper, when we would see a complete, uprise of the temperature or downrise, which is not really the case in Mr. Hill's situation. He did not cut off the tether. There was just a confirmed tamper, which occurred for a duration of 1 day, 16 hours, and 20 minutes, meaning that something got between the tether and his skin for almost 2 days before the tamper event did resolve, and it turned back to baseline on Wednesday, April 16th at 1:28 a.m.
Are you aware of any issues that Mr. Hill would be having with this device if he reported them to Ms. Fenlon, the person that installed it?
I have no information of that, and I will also say that the device does a self-diagnostic test approximately every 8 hours, and if there was an issue with the device, we would be notified immediately. The last time this device was serviced and calibrated was June 14th of 2024, and it takes 365 days of actual wearing use of it before we're required to do an annual maintenance on it, and neither of those scenarios did occur with Mr. Hill.
So in your paperwork, there's nothing to show that that device was actually serviced by Ms. Fenlon. We had an ice storm up here, and she went to everybody that was wearing these devices and serviced those. That's not in your report or your information.
It's not in the report I have in front of me right now. No, Counselor, it's not.
Okay.
And
so when there is a tamper going on such as this, where we're talking about over the course of longer than a day, do you notify the agency to notify the client that's wearing those devices?
And just to go back, I think the ice storm, that's when Miss Finland went to people's houses to direct connect their tethers, because people were without power, and the tether can actually store like up to 6 months of data. But I believe she drove to individual houses to direct connect and download that data into our mainframe. So I think that's what she did. And then the second question that you just asked me was in regards to do we notify, how we do the notification. So when there's either an alcohol event or a tamper event, the event must come to a completion for that information to be reviewed. And then if it gets reviewed and comes back as a confirmed event, then home confinement sends a report to the judicial entity, whether that be pretrial services, probation, etc. And then they review that, and then they're the ones who determine whether or not they're going to issue either a bond condition violation or a show cause hearing. We are just the electronic monitoring agency, so we report any violations and any confirmed events to the judicial entity.
So your testimony is that reporting only occurs after the event has taken place and goes back to normal?
Yeah, see, the alcohol tether is different than the SoberLink. SoberLink, you're going to get immediate results. I blew a .10 at 101 on today. It's going to give you that information. The alcohol tether is designed to capture an alcohol drinking or a tamper event. So we must wait. That's the way it's designed. You wait till the event is completed before that information is analyzed for either not confirmed or confirmed results, at which point that information is forwarded to the courts. So we wouldn't want to send any violation if it's still in process and it hasn't been reviewed. We can't do that.
So a violation could essentially be never ending.
Potentially, I guess, yes. I've never seen that, but potentially.
Yeah. Those are all the questions I have, Your Honor.
Can you redirect?
No, Your Honor.
Ms. Fryer, I have a question, if you could help clarify for me. The report says that alcohol was detected during the tamper, and you testified about transdermal alcohol from the skin. But then you also testified it didn't rise to some level for you to confirm an alcohol event. Can you describe for me the difference between alcohol being detected and a confirmed alcohol event?
Yes, I can, Your Honor. And in some instances, when there is an interference, meaning a tamper, something is placed in between the skin and the tether, then that alcohol detection technology can be compromised. So to answer your question, in regards to the strict protocol with that's required for a confirmed alcohol event. So we must start with a TAC, a transdermal alcohol concentrate of 0.000. That TAC level must reach to a peak state, then return back to a 0.000, meaning that event, that bell curve completed. The absorption rate must be less than 0.100 TAC per hour, because our bodies cannot absorb more quickly than that. And the elimination rate must be equal to or less than 0.035 TAC per hour, because once again, our bodies cannot eliminate more quickly than that. And then it also needs to pass the environmental contaminant factors, which could be anything that the device picks up environmentally. So for an instance, we had an offender who worked at a bar and someone spilled some beer near his ankle. So we saw a significant peak with that TAC reading and then a significant drop. But it did not come back as a confirmed alcohol event, because there would be no way our human bodies could absorb and then eliminate the TAC that quickly. So in this instance, the alcohol that was detected did not meet that strict protocol. Could it have been because there was a tamper? It could have been that because there was a tamper, that it couldn't do its job technology-wise. It was compromised because of the tamper.
Okay, so there, when there's alcohol detected, there was some transdermal alcohol detected by the sensor. But for whatever reason, those reasons could include the fact that the device wasn't functioning properly due to a tamper. You can't say what in the world was going on with any alcohol at all.
Yes, to answer your question, Your Honor, yes, there was a couple TAC readings that were received by the device, but it did not meet the strict protocols I went through with you, and therefore it did not come back as a confirmed tamper event. It just came back as a alcohol detected, because there was a alcohol detected. There was transdermal alcohol concentration levels that were detected. It just did not measure up and meet the strict criteria required.
Okay, thank you. Ms.
You're
Fitch,
welcome.
any questions as a result of the court's question?
Yes. Ms. Fryer, if it starts to detect alcohol, can the device be tampered by the defendant to prevent the full reading to be the alcohol to be confirmed?
Yes, as I did indicate, if something is placed between the skin and the alcohol tether, that could interfere and compromise the technology of the device to function properly, the way it's designed to function.
Okay, thank you.
Mr. Kukowski, any further questions on that topic?
Just briefly, Your Honor. And Ms. Fryer, are you aware of the CAM activity report, which says that the scram detected no alcohol events?
When I spoke to you earlier today, Counselor, when I returned your phone call, that is a moot point because it's not a confirmed alcohol event, and that does not really come into play here because I'm not here to testify that he did consume alcohol because it was not a confirmed event.
Thank you.
All right, thank you, Ms. Fryer. You're excused. I'm going to remove you now.
Thank you, Your Honor.
Any further proofs, Ms. Goodrich?
No, Your Honor.
Mr. Kukuski, any proofs from the defense?
I would be calling Oliver Hill to the stand, Your Honor.
Okay, Mr. Hill, if you want to come over to the witness stand here. As you arrive, if you can, as best you can, raise your right hand for me. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Okay, you can see it there.
State your name for the record, please.
Oliver Winston Hill, the third.
And Mr. Hill, we're here today regarding an alleged bond violation that occurred here in April on the 16th or the 14th through the 16th. Are you familiar with that
I am.
and the violation that's been alleged?
Yes, I am.
How long have you been wearing that ankle monitor, that tether?
Since January 31st.
Okay. And do you recall that device having to be serviced by Ms. Fenlon at any time during the time you've been wearing it?
Yes, I do.
When was that and what was the services?
It was just about 2 days before the storm that we had. She contacted me, came to my home, took it off my ankle, and I believe that she changed the battery in it because she assumed that we were going to lose power.
Okay. Were there any other times?
No, that was it.
Okay. Did you not in fact see her due to a problem when you arrived in the county jail?
Yes, I did.
And what was that for?
It was a little bit loose on my ankle,
Okay.
and there was a screw loose on it.
Okay. And Ms. Fenley came in and serviced that for you?
Yes, she did.
And when was that?
It was Sunday.
Okay. Now, during this time, you've been wearing that alcohol tether and you've been on the monitor there. You've also been doing urine screens. Is that correct?
Yes.
How often are you doing those?
In the beginning, it was twice a week. And then 1 week, I went like 3 days in a row. Then the following week, 2 days in a row. So it was basically 5 days in a row. So I called up to the court. I said, something doesn't seem right, you know? It's a lot of days in a row. So they reset it. And then after that date, it was once a week after that.
Okay. And did you in fact test and produce a urine screen on the 15th of April?
Yes, I did.
And did you get the results of that test to provide them to the court?
Yes, I did.
And I'm going to show you what's been marked as defense's proposed exhibit A. Do you recognize that exhibit?
Yes, I do.
And how do you recognize it?
I've seen it before.
Is this the test that you got from them
Yes.
regarding
from
the
Harbor
test that you took on the 15th?
Yes, it is.
Your Honor, I move for the admission of defendant's exhibit A.
Any objection?
Your Honor, I haven't seen it.
Okay, you want to show it to them?
No objection.
All right, exhibit A is admitted.
And the results of that test, can you tell me what they were, Mr. Hill?
They were negative.
Okay. And on the 15th, did you come to the courthouse, as a matter of fact?
Yes, I did. Right after I did the urinalysis.
What were you here for?
I came here to turn in my my SoberLink device.
What'd you see?
I took it. I first called Megan Fenlon, and she told me to bring it here and to give it to Emily Wergu.
Okay.
So I turned it in, and then I came upstairs and I went to the circuit court to inquire about a sobriety court, and then on the way downstairs, I seen Your Honor coming up as I was the last flight of stairs.
Okay, do you recall what time that was and when?
It was probably about 1:30-ish, approximately.
And if that test that you took on the 15th indicates that you took that test at about 11 o'clock, maybe quarter to 11.
Okay,
Did that verify your timeline better?
yes,
So you would have came to court after taking that test, so maybe closer to noon or 12:30?
correct. I'm
Okay.
sorry.
And so you're here in that building, how long were you here?
Not too long, probably about 10 minutes, possibly a couple more.
Have you had any other, since the time you've been placed on the alcohol tether and you've been urine screening through there, has there been any other violations or any other incidents?
No, there had not.
Now, you had Miss Fenlon come in and service your device because of a loose screw and a broken plate, did you say?
Your Honor, it's already been asked and answered.
Just sustained. I promise I'm paying attention.
Promise you're paying attention. Okay. Do you know how your device and the screw got loose on that device?
I have no idea, no.
Did you have any indication from Ms. Fenlon on how that might have occurred?
I'd object as to hearsay.
Sustained.
Those are all the questions I have, Your Honor.
Can you cross?
No, Your Honor.
You can step down, Mr. Hill. Any further proofs, Mr.
The
Kirkowski?
defense would rest at this time, Your Honor.
Any rebuttal proofs, Mr. Kirkowski?
No, Your Honor.
Argument, Mr. Kirkowski?
Your Honor, I would ask the court, based on the testimony of Lainey Fryer, to find that there was alcohol detected, even though it wasn't a confirmed event. It sounds like even the defendant can interfere with that being a confirmed event. And therefore, the tampering was a violation. Mr. Hill had been incarcerated due to sober link and violations. He was released and then returned to jail after this tether tampering, which had detected alcohol. As far as his testimony as to the battery being changed, or he said on Sunday, so May 4th, the nail or screw being tightened, I don't think that would interfere at all based on Ms. Fryer's testimony with the science behind the tampering. Thank you.
Thank you, Mr. Kirkowski.
Your Honor, we're here today for a bond violation in which my client has been alleged to have tampered and had a confirmed alcohol detection with his device. The burden of proof is on the people, and that burden would be beyond a reasonable doubt. At this time, the only testimony that we have from Ms. Fryer is that, well, there's deviations in this machine. It's about 99% accurate. I would question whether those devices and the admissibility of those devices, even in court, to meet that burden of proof. Again, my client has readily admitted any violations that he's had in the past. He's come to court, he's fallen on the sword, he's taken his lumps. He would, and I wholeheartedly believe would admit to a violation if he had one here today. But that's not the case. He's admitted maybe 3 violations in the past just on this file alone. He's had this device on his ankle since the 31st of January. Almost 3 months go by before there's any problem, any issue. He's done 17 drug urine screens in the meantime with no problem, no issue, no problem with this device. He's come to court on the 15th. If he's tampering with this device, sticking something in there to mess with the infrared sensor so he could drink alcohol, why the heck would he come to court in the county building on that day? And why the heck would he go drug test and drop urine on the 15th in the middle of this alleged violation and this alleged tamper event? Oliver Hill's a bright guy, but he's not that dumb to do that, Your Honor. And there's just not enough evidence or testimony that has been placed on this record today that would indicate to me, or should indicate to the court, that there has been a violation and that a violation has occurred. Mr. Hill has complied with this order. He's adamant he hasn't tested. He's testified today that Ms. Fenlon had to service that machine. A screw was loose on that machine upon entering the jail. Again, 83 days on that device, on that machine. And it wasn't until the 80th or just less than that day that he's alleged to have been tampered from this report. The report ends on the 23rd. So a significant period of time has lapsed. If there was a relapse or there was alcohol use, it would have occurred sooner, Your Honor. We'd ask the court to find that there has not been a violation of this matter. The prosecution has not met their burden of proof, Your Honor. Thank you.
Thank you, Ms. Goodrich, any rebuttal argument?
No, Your Honor.
All right, well, I'm going to find Mr. Hill in contempt of court for tampering with the alcohol tether. There is some question about whether alcohol was consumed or not. The alcohol detection on from the skin can't be confirmed that it was an event of consuming alcohol for the reason that, or it could be for any number of reasons, and one of them could be the device being tampered with, which that interferes with its ability to detect alcohol. That seems, I'm not surprised by that. That seems rather common sense. One mitigating fact there is on the 15th, right in the middle of the detection, right of the tamper window, there is a negative alcohol urine test collected on the morning of April 15th. The tamper with alcohol being detected continued past that date till the early morning hours of April 16th. But it's not really clear whether there was any alcohol being consumed or not by Mr. Hill. But what is clear is that there was something being done to interfere with that device's proper operation, which is designed to test for the presence of alcohol. So I think there certainly is proof beyond a reasonable doubt that Mr. Hill is in contempt of court for tampering with the device. So he's found in contempt. As to sanction, Mr. Kukuski, any allegation?
Your Honor, again, Mr. Hill throughout this case has readily admitted any problems or any violations that he's had with alcohol and alcohol use. He was incarcerated for 50 some days with a prior violation, and he's very adamant that this time he's not using or consuming alcohol, and it can't be, that fact can't be proven here today and was not proven here today. I would ask that the court allow him to be back out on bond on his device. He's got a lot of cleanup to do and work to get done. As I indicated the last time that we were here, the court was so gracious to put him on the ankle monitor, and he was very grateful. We are very grateful. We stand here very thankful to the court to allow us that opportunity. He went 3 months before this alleged tamper device, and I don't know how that happened, how the screw came loose. His plate had gotten cracked and Ms. Fenton had fixed it. But regardless, there was an issue with that device. It has been serviced, it has been fixed. And so given that and the time that he set now on this violation, waiting for his hearing, I asked the court to just sanction him to that time served, allow him back on bond so that he can provide for his family, take care of his mother, and do the things he needs to do to get his home clean since this whole event has happened in the ice storm. So thank you, Your Honor.
All right, thank you. Mr. Hill, you don't have to say anything, but before I decide on your sentence for the contempt, you are allowed to tell me anything. Is there anything you want to tell me about that or not?
Your Honor, I didn't do anything to this. I didn't tamper with it. I did the drug test. I had no idea that there was any, it wasn't a sock, there was nothing in between my ankle and that device.
Right, thank you.
That's all.
Thank you. Ms. Goodrich?
Your Honor, Mr. Hill, as mentioned, had violated on his silver link, which sounds like he had admitted to. Now he's violated with his tether. I believe he is a risk of public safety, and 93 days should be ordered with his bond continue to be revoked. It looks like the incident date of this underlying case is July 2nd of 2024, so it may be time for trial to be set.
Thank you. Well, I don't know whether Mr. Hill is guilty of the drunk driving that he's charged with or not. He has the right to trial about that, and we need to be scheduling one here, but when he's got 5 prior drunk driving convictions and at least 4 or 5 prior felony convictions on top of those, and a revoked license, and it's alleged that he's out with all that history driving drunk on that revoked license. So there's conditions placed on his bond so that we can be assured that Mr. Hill isn't placing the community at any risk of harm. He violated those bond conditions by using or drinking or both, and I revoked his bond. And then he sat 56 days on a revocation of his bond. And then, I think a lot of local attorneys can tell you, I don't give second chances when there's a violation of bond in that nature in a drunk driving case. I'm not entirely sure why I did for Mr. Hill, but that is not the norm for me to then cut you back loose into the community. But I did, but with a tether. So now I know I want continuous monitoring of your skin so that I can know that by me putting you back out, despite that prior violation, that I'm not endangering the public by putting you back out there among them. And, we've got evidence that I found that you tampered with that device. So that's just makes me regret reinstating bond in the first place, to be honest. So the sentence for that second contempt, the first one was 56 days. The second contempt is certainly not going to be less than that. So this will be a 93 days in jail, credit for 14 days previously served. Bond will continue to be revoked. So even at the conclusion of the contempt sentence, you can't be released again until I decide to reinstate your bond. All right, so Mr. Krupkeski, that takes care of the contempt issue. As to the underlying case, where are we at in terms of docket call?
Well, Your Honor, I did receive a recent emailed offer from the prosecutor that in fact, was just discussing with my client to see whether that was something that he'd be amenable to. Your Honor wants to set this matter for trial in a few months, then maybe an interim docket call so that we could discuss that.
Well, maybe I'd like to set it for trial if we're going to try it. I don't want to set it for trial if we're going to resolve it. So maybe I can have us come back next week, or you're not here you're not available on the 13th, is that, or are you available?
I don't believe I am available. I don't have my phone with me, Your Honor.
The only thing I've got you on is for Smiley for arraignment or plea taking. Oh, and Wheeler.
Smiley, I'm sorry.
Wheeler.
Okay.
So I mean, I could add this to next week's docket.
Let's do that.
And then you can review the offer with your client. And if it's resolved, we can go that way. If not, we'll set it for a trial.
That sounds good, Your Honor. Thank you.
Okay, so let's add it on for next week at 1:40.
Thank you, Your Honor.
Okay, anything further from the people?
There you go. Thank you.
Anything further from the defense?
Nothing at this time, Your Honor. Thank you.
Okay, Mr. Hill, we'll see you next week. Let's